While the IRS has since issued a statement saying it doesn't actually target taxpayers this way, many are very skeptical and some lawmakers are demanding answers. Joining me now to talk about it, Keisha Hebben, defense attorney and former prosecutor, and trial attorney Rachel Self. Good to see you both. Keisha,
yes.
You know, the documents that have been uncovered here through a Freedom of Information Act show that the IRS thinks they can read any electronic communication anytime of anybody without a warrant because they claim the Fourth Amendment doesn't apply. Let's put the Fourth Amendment up on the screen. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause. Papers, that's the key word there. And the founding fathers were very wise and prescient.
Right.
There's no material difference, is there, between an email and papers?
No, and I think that we need to keep in mind that when the founding fathers drafted the Constitution, there were no emails, there were no text messages, there was no Facebook or Twitter, but clearly the word papers would mean any type of permanent communication, such as an email or a text message. So I think it clearly, the IRS's policy clearly violates the Fourth Amendment to our Constitution.
You know, and Rachel, isn't there another federal law that applies here?
Yes, Greg. I think 18 U.S.C. 2511, the federal wiretapping statute, applies here as well. And I think that what the IRS is doing could be criminal in this case because it shall be considered a violation to intercept any oral, wire, or electronic communication without a warrant. So in this case, we don't have a warrant. We don't have probable cause. We have that pesky thing that law enforcers like to pretend they don't know about called the Constitution, which is, in fact, very important in this case, and they're relying on a law from 1986, okay, to say that they have the right to be doing this. Well, I'm sorry, I don't think that they do, and I think that this is really wrong.
And the internet was in its infancy back then. But look, the IRS, Keisha, has issued the following statement. We'll put it on the screen. Respecting taxpayers' rights and taxpayer privacy are cornerstone principles for the IRS. Oh, really? Then why does the IRS handbook say the following? We'll put that up. The Fourth Amendment does not protect communications held in electronic storage because internet users do not have a reasonable expectation of privacy in such communications. And guess what, Keisha? The current handbook, the most recent one, says the exact same thing.
Right, so clearly they're not getting it and they're not changing it, but what I think they're failing to realize that people do have a reasonable expectation of privacy in electronic communication. Most people are using that form of communication more than the postal service or more than paper communication. So I think that handbook definitely needs to be revised to reflect what the Constitution's intent is.
And Rachel, in 2010, there was a Sixth Circuit Court of Appeals ruling in which they said, yes, electronic communications are protected by the Fourth Amendment. And then, unbelievably, the special counsel to the IRS Criminal Division sent out an email saying, quote, I have not heard anything related to this opinion. Oh, really?
No, it's just, this whole thing is so shocking to me. And for them to say that they're not using these emails in any sort of investigation of any taxpayer, well, then they're wasting their time reading them. They shouldn't be reading them. And I believe that as much as I believe that people buy Playboy to look at the articles.
Do you think, Keisha, that this 1986 law, and again, you know, the internet was just getting off the ground, really. When they came up with this law that said, you know, you have to have a warrant for anything over 180 days, do you think that most people had sort of forgotten that law, except, of course, the IRS?
Absolutely. I think what happened was they did not think about what will happen now. And to be honest, I think they're using technology to distort or to not entail the seriousness of our Constitution.
Yeah, and you know what? 180 days? I mean, Rachel, isn't that the definition of arbitrary and capricious?
Absolutely. Absolutely, it is. And I think that it reeks of bad faith for them to know that this is unlawful in the Sixth Circuit and to then say, oh, but it hasn't been addressed in other circuits. So we're following the law in the Sixth Circuit, but despite the fact that we know in our guts that this is totally wrong to be doing, nobody's told us not to in other circuits. So we're just going to keep skirkling around in your emails. And I just don't think that that's right.
Yeah. And by the way, you know, the Supreme Court has said you can't enact laws that are arbitrary and capricious, which is why I use that phrase. But Keisha, you know, finally, expect Congress to take some action here to modify or throw out this law?
Yes, I do, and I think the other courts are going to follow suit with the circuit that has already decided that it's unconstitutional.
Yeah. All right, Rachel Self, Keisha Hebben, good to see you.